Everyone knew him as the witty Canadian actor behind Deadpool. But when Ryan Reynolds stood up in federal court that day, he was about to reveal a secret he had kept hidden throughout his Hollywood career. Not just comedic brilliance, but deep entertainment law expertise, years of studying contract negotiations and intellectual property protections, mastery of constitutional business law. Judge Clarence Thomas was dismissing him as just another actor trying to avoid contractual obligations, unaware that standing before him was someone who understood entertainment law better than most studio executives. Reynolds' first legal argument alone would completely transform the courtroom dynamics. "Your Honor, Judge Thomas," said Reynolds, his voice carrying the same sharp wit but now focused with legal precision, "may I speak to you about the Commerce Clause's relationship to entertainment contracts and the constitutional limits on corporate control over creative expression? What happened that day in the New York federal courthouse would revolutionize both entertainment law and our understanding of constitutional business protections." Before diving into this extraordinary fictional legal confrontation, don't forget to like this video and subscribe to our channel for more stories of unexpected legal brilliance challenging established authority. Thomas's world. Conservative constitutional authority, Judge Clarence Thomas represented the establishment conservative legal order. At 75, the longest-serving Supreme Court justice had built his reputation on originalist constitutional interpretation and strong support for corporate contractual freedom. A Yale law graduate with decades of judicial experience, Thomas embodied traditional approaches to business law and constitutional commerce. His judicial philosophy emphasized contract sanctity and limited government interference in private business arrangements. Thomas particularly supported corporate rights and viewed entertainment industry disputes as matters of private contract rather than constitutional concern. That day, his assumptions about Ryan Reynolds were predictable. Yes, Reynolds was successful in Hollywood. Yes, he had built an entertainment empire, but in Thomas's view, he was simply another actor using legal theatrics to escape legitimate contractual obligations rather than a serious advocate for constitutional business rights. This assessment would prove to be a significant miscalculation. Reynolds' hidden journey from acting to legal mastery. The world knew Ryan Reynolds through his entertainment evolution and business success, from Canadian television to Hollywood stardom, from Deadpool's massive success to building a multimedia empire, including Aviation Gin and Mint Mobile. His entrepreneurial achievements had made him one of the most successful actor-businessmen in entertainment. With deals worth hundreds of millions and creative control unprecedented for actors, Reynolds had redefined celebrity business power. But what the public didn't know was that Reynolds' business success had been built on intensive study of the legal frameworks governing entertainment contracts and constitutional business law. Starting in 2009, frustrated by restrictive studio contracts and inspired by his business ventures, Reynolds had begun serious study of entertainment law and constitutional commerce principles. The entertainment industry operates on contracts that would be illegal in any other business, he had confided to his wife Blake Lively during one of their business strategy discussions. "If I'm going to protect my creative freedom and help other artists, I need to understand the constitutional principles that should govern these agreements." Working with entertainment law professors from USC and NYU, Reynolds spent his time between projects studying Supreme Court contract precedents, constitutional Commerce Clause jurisprudence, and the intersection of creative rights with business law. He completed advanced coursework in entertainment law, constitutional interpretation, and the legal foundations of creative industry regulation. By 2023, when the case that would bring him to federal court emerged, Reynolds wasn't just defending his business interests. He was also a well-educated advocate for constitutional business rights, with genuine expertise in the entertainment law that governed creative industry contracts and corporate control. The Case Foundation: Creative Freedom versus Corporate Control. The federal case that brought Ryan Reynolds before Judge Thomas represented one of the most significant entertainment law challenges in Hollywood history. Reynolds vs. 20th Century Studios challenged the industry's standard exclusivity contracts as violations of both constitutional commerce principles and federal antitrust law. The case had emerged when Reynolds filed a comprehensive lawsuit claiming that major studios used exclusive dealing arrangements and creative control clauses to create an illegal monopoly over actor-producer relationships. He argued that industry-standard contracts violated constitutional commerce principles by restraining trade and suppressing creative expression. The implications extended far beyond Reynolds's situation. If his legal theory prevailed, it would fundamentally reshape Hollywood's business model and establish new constitutional protections for creative professionals. If the studios won, it would confirm that entertainment contracts could operate without constitutional constraint. For Thomas, this case represented an opportunity to defend traditional contract law while supporting corporate freedom. He viewed it as a straightforward matter of upholding legitimate business agreements against actor demands for special treatment. For Reynolds, the case was about fundamental constitutional principles, whether the Commerce Clause protected creative professionals from monopolistic practices, and whether entertainment contracts could constitutionally suppress creative expression and business competition. The setting: New York Federal District Court. The imposing courtroom of the U.S. District Court for the Southern District of New York was packed with entertainment lawyers, business law scholars, and industry executives. This case had drawn international attention both because of Reynolds's celebrity status and its potential impact on entertainment industry business practices. At the plaintiff's table sat Ryan Reynolds, dressed in a sharp charcoal suit that projected business seriousness rather than Hollywood glamour. His legal team from top entertainment law firms flanked him, though Reynolds had insisted on presenting key constitutional arguments himself, a decision that had surprised entertainment law experts. At the defense table, 20th Century Studios had assembled their most experienced entertainment attorneys, led by General Counsel Patricia Chang, a Stanford law graduate with decades of experience in studio litigation. Behind them sat executives from major entertainment companies, all confident this would establish important precedents protecting industry business models. Judge Thomas, presiding over this case due to its constitutional significance for commerce law, had already made his support for corporate contractual freedom clear through his previous business law rulings. First contact: the dismissive challenge. Mr. Reynolds, Judge Thomas began, his voice carrying the authority of decades in constitutional law, this court recognizes your commercial success in the entertainment industry. However, contract law involves established legal principles and legitimate business protections. Are you prepared to engage seriously with constitutional commerce doctrine rather than asserting creative objections to standard business practices? The question was designed to highlight what Thomas saw as the fundamental difference between entertainment success and legal expertise. His tone suggested he expected Reynolds to rely on his legal team or demonstrate the kind of constitutional superficiality he associated with celebrity business litigation. Reynolds stood deliberately, his posture respectful but confident. "Your Honor, I understand your concern about respecting established contract law. However, I'd like to address that concern by discussing the Supreme Court's analysis in Northern Securities Co. vi. United States and how antitrust principles apply to entertainment industry monopolization." A surprised murmur went through the courtroom. This wasn't the celebrity business dispute Thomas had expected. "The Sherman Antitrust Act," Reynolds continued, "prohibits contracts and combinations that restrain trade or commerce. When major studios use exclusive dealing arrangements to control creative professionals' ability to work with competitors, they violate these fundamental antitrust principles." Thomas's expression shifted slightly. The response demonstrated actual understanding of constitutional business law, not just entertainment industry talking points. Testing the constitutional waters. "Mr. Reynolds," Thomas continued, his tone becoming more serious, "citing antitrust statutes is one thing. Understanding how modern courts balance business efficiency against competition concerns is quite another. Are you familiar with how contemporary antitrust law evaluates exclusive dealing arrangements?" This was the kind of question designed to separate constitutional amateurs from serious business law practitioners. Reynolds nodded confidently. "Absolutely, Your Honor. The court's framework in Tampa Electric Co. v. Nashville Coal Co. establishes that exclusive dealing arrangements violate antitrust law when they substantially foreclose competition in the relevant market. The entertainment industry's standard contracts clearly meet this test. Thomas leaned forward, his interest clearly piqued. Continue with your antitrust analysis. The entertainment industry's exclusive dealing practices, Reynolds proceeded, substantially foreclose competition by preventing creative professionals from working with competing studios during their most productive years. This creates exactly the kind of market foreclosure that Tampa Electric prohibits. The courtroom had grown quiet. Entertainment reporters were taking detailed notes, and even the studio's attorneys were paying close attention to this unexpected constitutional discourse. The revelation: Reynolds's entertainment law expertise. "Mr. Reynolds," Thomas said, his tone now markedly different from his initial dismissiveness, "your constitutional analysis of entertainment business law demonstrates considerable legal sophistication. Where did you develop this expertise in antitrust law and constitutional commerce?" Reynolds's response would reveal the depth of his legal preparation. "Your Honor, I've spent over 15 years studying entertainment law and constitutional business principles, initially through USC Law's Entertainment and Media program, later through private study with constitutional scholars specializing in antitrust law and creative industry regulation. I've worked directly with Professor Jonathan Barnett at USC on entertainment contract theory, studied under Professor Tim Wu at Columbia on antitrust and creative industries, and completed advanced coursework through New York University's Business Law program, focusing specifically on the intersection of creative expression, business competition, and constitutional commerce." The courtroom buzzed with surprise. Thomas himself looked genuinely taken aback. "Moreover," Reynolds continued, "my practical experience as both creative professional and business owner has given me unique insight into how entertainment contracts affect competition and creative expression. I've seen firsthand how monopolistic practices stifle innovation and artistic freedom." Thomas's deeper constitutional challenge. Thomas, now taking Reynolds's argument seriously, decided to test the deepest level of his constitutional understanding. "Mr. Reynolds, your case essentially argues that private entertainment contracts violate federal antitrust law. But how do you address the legitimate business interests that exclusive arrangements serve, including investment protection and creative development?" This question went to the heart of modern antitrust law, the sophisticated balance between competition and business efficiency that typically separated legal generalists from serious antitrust practitioners. Reynolds's answer would demonstrate whether he truly understood the complexities of constitutional law in the business context. "Your Honor, there's a crucial distinction between exclusive arrangements that promote efficiency and investment, which antitrust law permits, and arrangements that foreclose competition to maintain market power, which violate constitutional commerce principles." He paused to organize his constitutional argument. The Supreme Court's decision in Standard Oil Company v. United States established that business arrangements violate antitrust law when their purpose and effect is to suppress competition rather than promote efficiency. Entertainment industry exclusivity serves the former purpose. Thomas was now fully engaged with Reynolds's constitutional analysis. "You're arguing that entertainment exclusive deals suppress rather than promote competition." "I'm arguing that when studios use exclusive arrangements to prevent creative professionals from working with competitors for extended periods, they're using contracts to maintain market power rather than promote efficiency," Reynolds responded. "This violates both antitrust law and the constitutional commerce principles that underlie competitive markets." The precedent analysis: building constitutional business framework. "Moreover," Reynolds continued, "we have direct precedent for limiting exclusive arrangements in creative industries. The Supreme Court's decision in United States v. Paramount Pictures broke up the studio system's vertical integration precisely because it used exclusive arrangements to suppress competition in film distribution." Thomas was taking careful notes. How does Paramount apply to contemporary actor-studio relationships? Paramount's constitutional principle applies directly to modern entertainment contracts, Reynolds replied. The court recognized that creative industries require competitive markets to serve both artists and audiences. When studios use exclusive arrangements to control creative professionals' career opportunities, they recreate the same anti-competitive practices that Paramount prohibited. Reynolds then presented his most sophisticated constitutional argument. The court's recent decision in Ohio v. American Express Company confirms that antitrust analysis must consider effects on all market participants, not just immediate contracting parties. Entertainment exclusivity harms not just individual actors, but competition throughout the creative economy. Thomas's constitutional recognition. The change in Judge Thomas was evident to everyone in the courtroom. His initial skepticism had evolved into genuine engagement with Reynolds's constitutional arguments. "Mr. Reynolds," Thomas said, "I must acknowledge that your constitutional analysis has been exceptionally sophisticated. You've presented antitrust arguments that merit serious consideration from this court." "Thank you, Your Honor," Reynolds responded. "I hope this demonstrates that constitutional business principles apply to all industries, including entertainment. The Commerce Clause protects competitive markets regardless of whether the products are widgets or creative expression." Thomas nodded thoughtfully. "Your argument essentially contends that entertainment contracts must comply with antitrust law like any other business arrangements. This raises fundamental questions about the relationship between creative industries and constitutional commerce." The industry's constitutional defense general counsel Chung, representing the studios, attempted to refocus the constitutional conversation. "Your Honor, while Mr. Reynolds's legal studies are noteworthy, the fundamental issue remains business certainty. The entertainment industry requires exclusive arrangements to justify substantial creative investments." Thomas turned to Chung with new interest in the constitutional balance. "Counselor, how does the industry respond to Mr. Reynolds's argument that exclusive dealing arrangements can violate antitrust law when they substantially foreclose competition?" Chung found herself defending industry practices against sophisticated constitutional arguments rather than dismissing celebrity business disputes. "Your Honor, entertainment contracts have traditionally received deference as specialized business arrangements." Reynolds was prepared for this constitutional response. "Your Honor, the industry's specialized business argument ignores the constitutional principle that no industry is exempt from antitrust law when it engages in anti-competitive practices. In Professional Real Estate Investors versus Columbia Pictures, this court held that entertainment companies receive no special immunity from antitrust enforcement. Constitutional framework development. Reynolds then presented his proposed constitutional solution. "I suggest a framework that protects both creative investment and constitutional competition. First, exclusive arrangements can protect specific projects without foreclosing general market competition. Second, exclusivity terms must be limited in duration and scope to serve legitimate business purposes. Third, industry practices must promote rather than suppress competitive markets for creative services." Thomas engaged directly with this constitutional framework. "How would your framework address industry concerns about investment protection and creative development?" "The framework protects legitimate investment while ensuring it serves constitutional commerce purposes," Reynolds responded. "Rather than market foreclosure, the industry can develop business models that promote competition and creative innovation. The Constitution requires this approach because antitrust law exists to serve competitive markets, not protect market power." Reynolds concluded with his strongest constitutional argument. Creative industries serve democratic culture, and competitive markets serve creative industries. When entertainment contracts suppress competition, they undermine both constitutional commerce and the creative expression that makes entertainment valuable. Thomas's final constitutional assessment. As the hearing concluded, Judge Thomas addressed Reynolds directly. "Mr. Reynolds, your constitutional arguments today have been remarkable. You've demonstrated understanding of antitrust law and constitutional commerce that rivals the most experienced business advocates." "Thank you, Your Honor. This case has never been about avoiding legitimate business obligations. It's been about ensuring that entertainment industry practices serve constitutional commerce principles rather than suppressing the competition that promotes creative innovation. Thomas reflected on the broader constitutional issues. Your arguments raise fundamental questions about the application of antitrust law to creative industries. This court will examine them with the constitutional rigor they deserve. The landmark entertainment law decision. 2 weeks later, Judge Thomas issued a comprehensive 41-page decision that would reshape entertainment law and constitutional business jurisprudence. The ruling found that industry-standard exclusive arrangements violated antitrust law when they substantially foreclosed competition in creative services markets. More significantly, Thomas's opinion adopted key elements of Reynolds's constitutional framework, creating new precedent for how courts would evaluate entertainment industry practices against antitrust and constitutional commerce principles. The decision included an extraordinary judicial acknowledgment. This case demonstrates that constitutional commerce wisdom can emerge from practical business experience in regulated industries. Mr. Reynolds's analysis has contributed meaningfully to this court's understanding of antitrust law in creative markets. Broader constitutional and industry impact. The Reynolds versus 20th Century Studios decision created immediate changes in entertainment industry practices and sparked national conversation about competition and creative freedom. Antitrust scholars praised the decision as a landmark victory for competitive markets in creative industries. Law schools immediately began incorporating Reynolds's constitutional arguments into their antitrust and entertainment law curricula. The case became required reading for business law, constitutional law, and entertainment law courses nationwide. For the entertainment industry, the decision established crucial precedents requiring competitive business practices while preserving legitimate investment protections and creative development arrangements. Long-term constitutional legacy. The constitutional precedents established in Reynolds versus 20th Century Studios influenced business law for years afterward. The decision's framework for applying antitrust law to creative industries became a model for courts addressing competition and constitutional commerce. Most importantly, the case demonstrated that constitutional expertise could emerge from business experience and that the most meaningful antitrust arguments often came from those who understood both competitive markets and industry practices. Ryan Reynolds had proven that true constitutional advocacy for business rights requires combining practical business knowledge with rigorous legal scholarship, and that protecting competitive markets demands the same constitutional courage that has always been necessary to defend economic freedom. If you found this incredible fictional story of business constitutional courage and hidden legal brilliance inspiring, please hit that like button and subscribe to our channel for more amazing tales of unexpected expertise challenging established authority. Ring that notification bell so you never miss these extraordinary fictional stories of how constitutional knowledge and business experience can combine to protect competitive markets. What did you think of this fictional portrayal of Reynolds's constitutional expertise? Share your thoughts in the comments below. Important note: this is a completely fictional story created for entertainment purposes. Any resemblance to real events or persons is purely coincidental.